Hey guys, we're back for the next lesson. And in this lesson, the last lesson we spoke about setting up the appointment with the sellers. Let's assume you've created a comfort level. They're okay with selling you the property for what they owe. Basically, you're taking the property subject to the existing financing. You're keeping the existing financing in place. You're just taking it over. Basically, you can exchange title. The title can transfer. The existing financing can stay in place. You just have to make sure you make payments on the payments. Make sure it's something you can afford, especially if it's something you're going to move into. If it's a house that you're going to sell, obviously you're going to want to make sure that that payment is in line with the market for that area. Now, assuming we've had the agreement, we got the purchase and sale agreement signed, we had the authorization to release signed. You need an attorney. I'd rather use an attorney than a title company because a title company is going to want to insist that you get title insurance. Um, you don't need title insurance at this point. You can always get that later when you sell. Um, Basically, what you want to do is you want to close it with a real estate attorney. The ways of finding a real estate attorney, I mean, you can find real estate attorneys online through the yellow pages. I recommend finding them through your local real estate investment club. Attend one of their monthly meetings or weekly meetings. Ask around who's a good real estate investor attorney that closes owner finance deals, and I'm sure that you're going to find somebody who uses them regularly, and they're more open and they understand exactly what you're doing. Once you find that attorney, you have their number, you've spoken to them, you have a meeting of the mind, so to speak. They understand what you're doing. You're faxing over the purchase and sale agreement to them so they can do a title search. The title search is so that you can check them, make sure there's no liens or encumbrances on the property. Liens are not that big a problem depending upon the nature of the lien. However, you may have to get them removed or transferred just depending on the situation, but you want to make sure that the person you bought the house from has clear title. You might have somebody in the house that doesn't even own the house, so you just want to make sure, do your due diligence, transfer is fax over the purchase and sale agreement, have them do the title search. Should only take about a day or two. Once you have clear title, you go ahead and set up closing. You call the sellers back, or even while you're there, you can ask them what days they're available, so because you're going to set that up. But once you have clear title, you call them back and you let them know, hey, we got clear title. Um, can we go ahead and set up closing next week, or Monday, Tuesday, Wednesday, whatever. You meet, try to fit it within their schedule, obviously. Let your attorney know. Now, most attorneys on owner finance deals, they're going to charge between a range of as low as $250, because I've done that myself, to as high as about $1,000. You're going to have to determine what you feel comfortable with. Um, and I guess it depends really if you're going to move in the house or not, because if I'm selling the house, and I can get an agreement I have a good rapport with the attorney. I can say, hey, I'm going to we're going to do closing for the seller and then closing for the buyer. We're going to take care of all the closing costs when we get to the buyer. They're going to hold all the documents anyway. Oh, and by the way, you want over here, you'll notice I have send your document closing docs. You want to send a CYA disclosure. That's what we call it. Cover your, disclosure. Basically, it's disclosing to the seller that there's a due on sale clause in the mortgage. Most mortgages have a due on sale clause, meaning that the bank or the lender has the option of calling the loan due if title transfers. They have that option. I've never heard of it being exercised in normal circumstances. And I've been doing this for over 10 years. And I know people that have been doing it 30 years and they've never had an issue with it actually being called. So some people make an issue of that, saying they act like it's a big deal. And it's a clause, guys. It's not a law. It's a clause within an agreement. So it's not that big a deal. So don't make it into one. But you just want to have it disclosed to them that that's a possibility. But, the chances of it happening is the same as getting struck by lightning. So if that. Basically, you want to send over a wraparound mortgage, which is also called an AITD, an all-inclusive trust deed. Not a deed of trust, but an AITD. You want to send over or if it makes sense, if you're in another state, to use a land contract, use a land contract. Or if you're not taking title of the property, you're actually getting it on a lease option or a lease purchase. You can just send over the lease paperwork for the attorney, and that's fine. Um, a lot of people push the lease option and lease purchase as a way to get into properties easily. I don't like to lead with that. I think that's the easy way out. I like to try to get the title first. If they don't feel comfortable giving the title, then that's a fallback. But I don't like to lead with it. I think people have an over reliance upon leading with it. That's just my opinion. I'm just saying. So you have the CYA letter disclosures, you have the mortgage, and you just want your attorney to look them over and see if they see any issues that they may run across. And they, sometimes they want to draft up their own or alter yours. That's fine, whatever. And you want to have a deed. You can use a warranty deed, general deed, or a warranty deed to trustee. Some people make an issue of putting it in. Uh, I like to take deeds into a LLC or a corporation if it's just a regular deed or a warranty deed or general deed. A warranty deed to trustee, that's basically putting the deed into trust. And it's just so names aren't on public record. I've learned this from people that play at a certain level, millionaires, multimillionaires that have been doing real estate, and you're just basically using the games that they use. You're just playing at the same level they're playing at. It's not in the mainstream, which none of this is, so and that's why this is real valuable information. However, some people make an issue of putting it into a trust. Banks put deeds into trust. So, if banks can do it, you can do it. Corporations can do it. It's not a big deal. So don't let somebody make you think that it is, because it isn't. Um, Again, your cost can range with a closing attorney between $250 to $1,000. Some of them want their money up front. Some will wait till you close one portion. Some will wait all the way to the end. It just depends on what you can negotiate with that attorney, what kind of rapport you have with them. And it may determine whether or not you're going to live in the property or whether you're going to sell it. Obviously, if you're going to live in it, you're going to cover the closing costs. I mean, it makes sense. Typically, what I like to do is I explain to the sellers that when they closed originally on their loan, on their mortgage, their first monthly payment wasn't due until 30 days later, because interest accrues in arrears. You don't pay interest in advance because it hasn't accrued yet. Same thing when they close. So they have to make the next month payment for that house. So that gives you 30 days grace, so to speak. I'll usually request a second and a third month as well payment, because I'm covering the closing costs. I mean, usually they'll have to pay anywhere from $3,000-4,000 in closing costs, maybe more in a lot of cases, depending on your state and the value of the house. So I think it's a good trade-off for maybe 2 additional payments and not have to worry about closing costs. So that gives you a little grace period before you have to start making payments again. So since you're not making payments for 30 days and ideally up to 90 days, I mean, it shouldn't be any problem covering the closing costs. I mean, it's a net win for you. If you have a buyer coming into this transaction, say this is not a house you're going to live in, you have a buyer coming in, set it up that the buyer pays all the closing costs. I mean, it's not that expensive. Even if they pay $2,000, that's a lot less than what they would have to spend for closing costs for a conventional real estate transaction through a conventional lender. They would have to pay a great deal more than that. They would have to pay appraisal fees, uh, uh, inspection fees, surveys, uh, all that, including plus percentage. So it's a trade-off that they shouldn't have a problem with. Plus, they're getting in a house with essentially no bank qualifying, very limited credit check. You're not really disqualifying them for the same reasons that a conventional lender would disqualify them for. So they shouldn't have a problem with that. So if you look on the screen, you'll see you want to make sure to get those things covered. At that point, you determine that what date you want to move in. But once you have the purchase and sale agreement signed and you send it over to the attorney, if you're selling the house, you can go ahead and market the house for sale. Go ahead and get some pictures. I like to have the sellers take pictures of the inside, take pictures of the outside. send them to you via email from their phone or their digital camera, what have you. That way you can go ahead and start marketing the house, and it shouldn't take you long before you get some interest. If you, if you go ahead and compose your ad correctly. Excuse me. If you're going to move into it, obviously you're going to have to schedule a time for them to move out. I usually like to include in the paperwork a occupancy agreement where they're agreeing to move out by a certain amount of time, otherwise get penalized. Obviously, if you have title, you do have uh, obviously authority to evict them if they exceed that, or if they start making an issue later. So that's why I like having title as opposed to using lease option or lease purchase as a fit all for taking over a property with no money or no credit. So that's the portion of taking title, of actually getting your house with no money and no credit. Essentially, again, you may, if you can't find an attorney, you may have to cover some of the closing costs. But again, if you're getting grace where you don't have to pay the mortgage for 2 or 3 months, if you're moving in, if you're getting a new buyer in, and you're going to get them to cover all the closing costs, so you're getting a net win here, so you're not losing anything. All right, now the next lesson is putting your ad up if you want to sell the house, or putting the ad up basically if you want to sell it. And we'll just go into that into the process of actually selling the house. So until then, just hold tight for the next lesson.